Thank you. Please be seated. Okay, good morning. We are on the record on case CR 22-21-1624, State of Idaho versus Lori Vallow. The matter is continuing through trial. State continues with its case in chief. The court would note the prosecutions here present, as well as the defendant and the defense. The court had a conference with counsel this morning in regards to a legal issue that's arisen in the case with the current witness that's being questioned, and that's Mr. Pulowski. On cross-examination, the defense has indicated it wishes to have admitted and published certain recordings that were made by the witness, and the court is considering whether or not those should be admitted in the case or be allowed to be published to the jurors. The court's determined that it's a legal issue that would be best determined outside of the presence of the jury, since there needs to be a proffer to the court about what the contents of the exhibit may demonstrate, and it would be improper for the jurors to hear that in the event that the court determines the evidence is not admissible. So at this point, I'd like to hear argument on the record as to what is intended to be introduced here in these recordings. If the defense could lay a record of that, including any proffer of what you would say the recordings would show and how those would be relevant and admissible. And then if there's any objection, I'll hear that from the state. So, Mr. Archibald.
Your Honor, first of all, I'll point out to the court that I did ask for Ian Pulowski to be dismissed yesterday, that he not be allowed to testify at all. But since he was allowed to testify, Mr. Pulowski has now testified that he is what a defense lawyer would call a snitch. A secret recording at the direction of law enforcement. So Mr. Pulowski, he's testified so far that he dated Melanie Bedreau for, I can't remember, a couple of weeks. They got married in Vegas, and then he contacted law enforcement a week later, and at the direction of law enforcement, he became a snitch with some secret recordings. So the state has asked Mr. Pulowski some of the content of these secret recordings, and the witness has identified a couple of issues. That the cops are possessed, that neither Chad nor Lori make any confessions of a crime. So in preparing our cross-examination, we have gone through these recordings. They were provided in discovery. I will note that we reviewed them last night. I sent an email to the prosecutors pointing out that these recordings are in the state's discovery disclosure dated August 9th of 2021, Addendum A. They're listed on the state's witness and exhibit list dated March 20th of 2023 on page 15 of 18. They're listed on our witness and exhibit list dated March 20th, 2023, page 6, item 1, where we just say anything that the state has is ours as well for witnesses and exhibits. So this recording that we would like to play this morning is from Ian Pulowski, recording number 9. It's on December 12th or December 13th. It's a conversation secretly recorded by Ian Pulowski. His new wife, Melanie, is talking on the phone with Chad Daybell and Lori Daybell, and they are discussing several issues: the death of Alex, the religious issues, a blessing from Chad, and I'll remind the court that these religious issues are charged by the state as an overt act, that this conspiracy that my client is being accused of is due in part to religious issues, religious beliefs, that the religious beliefs are in and of themselves an overt act, part of a crime. So that's why we would like to play recording number 9. The witness has identified it. He's admitted that he recorded it, that he has made several recordings, and we believe this tape is not burdensome in nature. There are several hours worth of tapes. This one is less than an hour. I think it's about 50 minutes, roughly, give or take. And so that is why we would like permission from the court to play this recording.
Let me just ask, Mr. Archibald, in lieu of publishing or playing the recording, why would you prefer that versus just being allowed to cross-examine on the contents of that recording, and then perhaps have an option if you were to impeach the witness with inconsistent statements versus what he says on the stand in relation to what's in the recording?
The recording is the best evidence. It contains the statements of the religious issues as alleged by the state. It contains the actual statements. The state has tried to get Mr. Pulowski to summarize. We don't believe his couple of statements that he's made about the summary are a fair and accurate summary of what happened here. So we would prefer the best evidence, which is the recording itself.
All right. Thank you, Mr. Archibald. Who's going to argue any objection by the state?
I will, Your Honor.
All right, Ms. Blake, what's the state's response to the proposed admission of these recordings?
Thank you, Your Honor. First, I would indicate, I think it is objectionable to refer to the witness in this case as a snitch. In this case, what Mr. Pulowski had testified to is he had concerns for his own safety and the safety for those around him, and was trying to assist police in locating missing children. So I did take objection to that. Outside of that, with regard to Mr. Pulowski's testimony, I don't think at no point was he asked to provide a summary of any recordings. He was asked about making the recordings, but prior he was asked about some of the religious teachings that Lori purported to have and that she either taught or told to him. With regard to the recordings themselves, there's several issues with them. The first one being hearsay. We have different individuals on there: Melanie, Lori, Chad, and Alex as who's purported to be on there, is my understanding. With regard to that, I recognize some of those individuals are not Lori, but specifically with regard to the defendant, statements are allowed for use against a party by the party opponent. They're not generally allowed to be introduced by the party themselves into a case. So I think there's a problem with that. I do believe that these would be contain potentially self-serving statements, and not in the sense that she knew she was being recorded, but in the sense that the defense is going to try to use them for the truth of the matter. If they're not going to be used for the truth of the matter, then we get into the fact that they simply aren't relevant. With regards to any statements made by the others, statements made by a co-conspirator, there's case law saying those are not necessarily allowable by another co-conspirator. Again, they're allowed to be used by the party opponent, but not another party in the case. And maybe this is the one that Alex was not present for, but that would apply to Chad as a co-conspirator. So given the concerns with that, because I think it does become a circular argument that either it is hearsay and it is being admitted to prove the truth of the matter, and or it is a self-serving statement. If it's not being used for any of those things, then it wouldn't be relevant. Further, the defense has continued to say that religious beliefs have been made a part of this case and that it's an overt act. I want to be very clear. Religious beliefs are not an overt act as charged by the state. What the state has charged is, as an overt act or included as an overt act, is that the defendants espoused religious beliefs or purported religious beliefs, and the theory being that they use those to try to manipulate and control others. There's been no overt act that they actually held or believed these things. So if that's what's going to be demonstrated as well, I do not think that's contained within the charging document of the state, and that was not the intention of that overt act. So for all those reasons, we would object to the playing of the tape of the recording at this time. And we believe the defense could cross on what has been asked. They have access to the tapes, they've listened to them, and they can cross Mr. Pulowski regarding those.
All right. Thank you, Ms. Blake.
May I respond, Your Honor?
Yes.
To something she brought up. In a conspiracy case, what Chad says is not hearsay. We've allowed a lot of Chad's statements in during this trial, weeks and weeks worth of Chad's statements. And the reason is because co-conspirator statements are not hearsay. Same is true with Alex. Alex is charged as a co-conspirator. His statements are not hearsay. The state has also alleged unknown conspirators. This could include Melanie Bedreau, Melanie Pulowski. So her statements as a co-conspirator would also not be hearsay under the conspiracy rules. So this is not a self-serving statement. Lori didn't know she was being recorded.
Thank you. Please be seated. Okay, good morning. We are on the record on case CR 22-21-1624, State of Idaho versus Lori Vallow. The matter is continuing through trial. State continues with its case in chief. The court would note the prosecutions here present as well as the defendant and the defense. The court had a conference with counsel this morning in regards to a legal issue that's arisen in the case with the current witness that's being questioned, and that's Mr. Pulowski. On cross-examination, the defense has indicated it wishes to have admitted and published certain recordings that were made by the witness, and the court is considering whether or not those should be admitted in the case or be allowed to be published to the jurors. The court's determined that it's a legal issue that would be best determined outside of the presence of the jury, since there needs to be a proffer to the court about what the contents of the exhibit may demonstrate, and it would be improper for the jurors to hear that in the event that the court determines the evidence is not admissible. So at this point, I'd like to hear argument on the record as to what is intended to be introduced here in these recordings. If the defense could lay a record of that, including any proffer of what you would say the recordings would show and how those would be relevant and admissible. And then if there's any objection, I'll hear that from the state. So, Mr. Archibald.
Your Honor, first of all, I'll point out to the court that I did ask for Ian Pulowski to be dismissed yesterday, that he not be allowed to testify at all. But since he was allowed to testify, Mr. Pulowski has now testified that he is what a defense lawyer would call a snitch, a secret recording at the direction of law enforcement. So Mr. Pulowski, he's testified so far that he dated Melanie Bedreau for, I can't remember, a couple of weeks. They got married in Vegas, and then he contacted law enforcement a week later, and at the direction of law enforcement, he became a snitch with some secret recordings. So the state has asked Mr. Pulowski some of the content of these secret recordings, and the witness has identified a couple of issues. That the cops are possessed, that neither Chad nor Lori make any confessions of a crime. So in preparing our cross-examination, we have gone through these recordings. They were provided in discovery. I will note that we reviewed them last night. I sent an email to the prosecutors pointing out that these recordings are in the state's discovery disclosure dated August 9th of 2021, Addendum A. They're listed on the state's witness and exhibit list dated March 20th of 2023 on page 15 of 18. They're listed on our witness and exhibit list dated March 20th, 2023, page 6, item 1, where we just say anything that the state has is ours as well for witnesses and exhibits. So this recording that we would like to play this morning is from Ian Pulowski, recording number 9. It's on December 12th or December 13th. It's a conversation secretly recorded by Ian Pulowski. His new wife, Melanie, is talking on the phone with Chad Daybell and Lori Daybell, and they are discussing several issues: the death of Alex, the religious issues, a blessing from Chad, and I'll remind the court that these religious issues are charged by the state as an overt act, that this conspiracy that my client is being accused of is due in part to religious issues, religious beliefs, that the religious beliefs are in and of themselves an overt act, part of a crime. So that's why we would like to play recording number 9. The witness has identified it. He's admitted that he recorded it, that he has made several recordings, and we believe this tape is not burdensome in nature. There are several hours worth of tapes. This one is less than an hour. I think it's about 50 minutes, roughly, give or take. And so that is why we would like permission from the court to play this recording.
Let me just ask, Mr. Archibald, in lieu of publishing or playing the recording, why would you prefer that versus just being allowed to cross-examine on the contents of that recording and then perhaps have an option you were to impeach the witness with inconsistent statements versus what he says on the stand in relation to what's in the recording?
The recording is the best evidence. It contains the statements of the religious issues as alleged by the state. It contains the actual statements. The state has tried to get Mr. Pulaski to summarize. We don't believe his couple of statements that he's made about the summary are a fair and accurate summary of what happened here. So we would prefer the best evidence, which is the recording itself.
All right. Thank you, Mr. Archibald. Who's going to argue any objection by the state?
I will, Your Honor.
All right, Ms. Blake, what's the state's response to the proposed admission of these recordings?
Thank you, Your Honor. First, I would indicate I think it is objectionable to refer to the witness in this case as a snitch. In this case, what Mr. Pulaski had testified to is he had concerns for his own safety and the safety for those around him and was trying to assist police in locating missing children. So I did take objection to that. Outside of that, with regard to Mr. Pulaski's testimony, I don't think at no point was he asked to provide a summary of any recordings. He was asked about making the recordings, but prior he was asked about some of the religious teachings that Lori purported to have and that she either taught or told to him. With regard to the recordings themselves, there's several issues with them. The first one being hearsay. We have different individuals on there, Melanie, Lori, Chad, and Alex as who's purported to be on there is my understanding. With regard to that, I recognize some of those individuals are not Lori, but specifically with regard to the defendant, statements are allowed for use against a party by the party opponent. They're not generally allowed to be introduced by the party themselves into a case. So I think there's a problem with that. I do believe that these would be contain potentially self-serving statements, and not in the sense that she knew she was being recorded, but in the sense that the defense is going to try to use them for the truth of the matter. If they're not going to be used for the truth of the matter, then we get into the fact that they simply aren't relevant. With regard to any statements made by the others, statements made by a co-conspirator, there's case law saying those are not necessarily allowable by another co-conspirator. Again, they're allowed to be used by the party opponent, but not another party in the case. And maybe this is the one that Alex was not present for, but that would apply to Chad as a co-conspirator. So given the concerns with that, because I think it does become a circular argument that either it is hearsay and it is being admitted to prove the truth of the matter, and or it is a self-serving statement. If it's not being used for any of those things, then it wouldn't be relevant. Further, the defense has continued to say that religious beliefs have been made a part of this case and that it's an overt act. I want to be very clear. Religious beliefs are not an overt act as charged by the state. What the state has charged is, as an overt act or included as an overt act, is that the defendants espoused religious beliefs or purported religious beliefs, and the theory being that they use those to try to manipulate and control others. There's been no overt act that they actually held or believed these things. So if that's what's going to be demonstrated as well, I do not think that's contained within the charging document of the state, and that was not the intention of that overt act. So for all those reasons, we would object to the playing of the tape of the recording at this time. And we believe the defense could cross on what has been asked. They have access to the tapes, they've listened to them, and they can cross Mr. Pulaski regarding those.
All right. Thank you, Ms. Blake.
May I respond, Your Honor?
Yes.
To something she brought up. In a conspiracy case, what Chad says is not hearsay. We've allowed a lot of Chad's statements in during this trial, weeks and weeks worth of Chad's statements. And the reason is because co-conspirator statements are not hearsay. Same is true with Alex. Alex is charged as a co-conspirator. His statements are not hearsay. The state has also alleged unknown conspirators. This could include Melanie Bedreau, Melanie Pulowski. So her statements as a co-conspirator would also not be hearsay under the conspiracy rules. So this is not a self-serving statement. Lori didn't know she was being recorded. No one knew except Ian and law enforcement. And so that's why this is admissible.
All right, thank you, Mr. Archibald. If you give me a moment here, please. All right, I'm going to take a brief recess to chambers to discuss this legal issue with my staff attorney and develop a decision on that. It shouldn't take long at all, and we'll advise the jury that they're being held while this decision's made. So just as soon as we can sort this out, I'll come back on the record, make a ruling on the matter, and then we'll have the jurors brought in to start with additional testimony.
All right.
Thank you. Please be seated. All right, thanks for your patience. The court is back on the record on case CR 22-21-1624. Considered a request by the defense to play a recording that was made by the witness who's currently on the stand, Mr. Pulowski. There's been an objection made by the state citing concerns that it would violate the rules of evidence as it relates to hearsay. Some other arguments made by the state is that there would not be adequate foundation or it may not be relevant. On those points, the court does find that there may be relevancy because at least some of the content could have been raised in direct examination where it was under direct of the state that the witness indicated the recordings existed and made some reference to those recordings. In addition, the court believes a foundation could be established by the witness since the witness is the party that did create the recordings and would likely be able to identify those as the recordings that he made at the request of law enforcement. The issue that comes up then is whether or not this would constitute hearsay and be excluded by the rules of evidence as it relates to hearsay. And hearsay rules have a lot of exceptions. One of the exceptions that's been argued by the defense is under the Rule 801D2E that talks about statements of a co-conspirator. And in looking at the rule there on 801D2E, it's not hearsay if it's made by a co-conspirator during and in furtherance of the conspiracy, and that would be offered by an opposing party. So here the court finds that would not apply because it's not, first of all, the opposing party that's offering these statements, it's the party themselves, and second, there's no indication that there are indications within the recordings that the statements made were in furtherance of the conspiracy. So the court's also done some research in case law. There's a case, State versus Rollin, R-O-L-O-N, 146 Idaho 684, that talks about whether or not all conversations between co-conspirators are admissible as not being hearsay if looking at that rule, and talks also that it's a limited exception, that it's limited to statements that are made in furtherance of a conspiracy. Having considered that, the court has also considered the argument on the completeness doctrine and whether or not any of the statements made on direct were subject to the completeness doctrine, but they were basically generalized statements and haven't heard any testimony at this point that would satisfy the need to correct what the witness said or impeach him through the means of the completeness doctrine. So with those findings, then, the court does find that the recordings would constitute hearsay and are not admissible under the hearsay rules. I would, however, indicate that on cross-examination, if the witness were to contradict the contents of those recordings, I think that may open another opportunity for them to be played as a means to impeach the witness, which would likely be permissible at that point. But with the state of the record where it is, the court finds that the hearsay objection made by the state will be sustained and will not allow the playing of the recordings at this time. So that's the court's ruling on that issue. Do you have any questions on my ruling, Mr. Archibald? All right, thank you. Any questions from the state?
No, Your Honor.
Okay, thank you. With that, then, we'll have the jurors brought in, and Mr. Pawlowski can resume testifying from the stand. They're bringing the jurors. Thank you. All right, thank you, Mr. Bailiff. Please be seated. Ladies and gentlemen of the jury, welcome back this morning. I understand they've all submitted their juror affirmations today. Is that correct, Mr. Bailiff?
Yes, Your Honor.
All right. Thank you again for your continued service. Apologies for the delay in bringing you in this morning. The court was conducting a matter outside of your presence as it relates to some evidence that was in dispute in the case. We've got that resolved at this time. I'll note that Mr. Pulowski was previously sworn in this case, and I believe where we ended yesterday, the state had completed direct examination, so at this point it would be time for defense to conduct cross-examination. So, Mr.
I'll be doing that, Judge.
Thomas, all right, Mr. Thomas, if you'd like to conduct your cross-examination of this witness, you can do that. And before you start with your testimony, let me just confirm again with the witness, did you, between the time we ended court yesterday and this morning, did you read any of the trial testimony, look at anything about the case, or do any investigation of the case since yesterday? Okay, thank you, Mr. Pulowski. So, Mr. Thomas, then, if you'd like to commence with direct, you can do that.
Is your microphone on?
I think it is now.
Okay.
Can you hear me?
Mr. Pulowski, how are you this morning?
Doing all right?
Good.
As can be, I guess.
Right? Okay. So, yesterday, we went through the direct examination of you, fairly brief. Let's get a little bit more background on what we were talking about yesterday, if that's okay. It looks like you met Melanie sometime in November of 2019, is that correct?
Yes.
And Melanie is your wife?
Yes.
Her name then was what?
Her last name was Boudreaux.
Okay. And she was going through, or she had just recently been divorced, is that right?
I'm not positive, but yeah, it was a few months prior that the divorce had finalized.
Okay. And do you know who her ex-husband is?
Yes.
Okay. And you've had some dealings with him?
Not personally.
Well, through court and those kinds of things?
Melanie has.
Melanie has. Okay. You don't go to court with her?
I haven't, because of COVID, I was not allowed in the courtroom.
Oh, I see. Okay. All right. And so you met her, and then you got married to her shortly after you met her, is that correct?
Yes.
And how long had you guys dated before you got married?
It was 10 days.
10 days?
Yes.
Okay. And you got married in Las Vegas, Nevada, is that correct?
Yes.
Okay. You indicated on direct examination that you had talked to Lori Vallow, and that you actually, I believe you said you had to ask, or not had to ask, but you asked Chad Daybell and Lori Vallow for Melanie's hand in marriage. Is that right?
Yes.
Okay. Very chivalrous. And you did that because Melanie, she doesn't have parents, or what's the deal with that?
At that time, Chad and Lori were the closest relatives that she had. She trusted them more than anybody else in her family at the time.
Okay. And do you know that whether or not her mother is still alive?
No, her mother passed away when she was young.
Right. Okay. Okay. You talked about hearing the term casting or casting out. Is that right?
Yes.
Okay. Tell me a little bit about that. What did you hear about, and who did you hear it from?
So there were references to it during phone calls that I heard. Basically, my understanding is that with casting, you're trying to expel a possession, demonic, disembodied spirit, or they were getting into this bug kind of possession that they were talking about, where something would crawl into your ear or your brain that would take you over. And so there were references to that during the phone call. Casting, you would pray to force that possession, the possessor, out of the body.
Okay. And some of those phone calls that you're referencing, some of those phone calls were recorded. Is that right?
Correct.
And you recorded those phone calls?
Yes.
And that was at the request of law enforcement?
Yes.
Specifically the FBI?
Yes.
Okay. Are you currently working with the FBI in any capacity?
No.
Not in any capacity in another case or anything else?
Not at all.
Okay. When did you stop working for the FBI?
It was approximately 2 weeks after I started.
So you only did this for 2 weeks?
Mm-hmm.
All right. Who knew that you were recording these conversations?
It's myself and the FBI.
Okay. And this was after you were married?
Yes.
And your wife didn't know you were recording?
She did not.
Does she know now?
Yes.
I want to take you to December 12th, 2019. Do you recall that specific day?
No. You'll have to refresh me.
If I were to tell you that that's the day that Alex Cox died, would that refresh your recollection?
Absolutely. Yes.
Okay. That was a pretty significant date for Melanie, right?
Yes.
And you were part of Melanie's life, and you were trying to be there for Melanie.
Yes.
Okay. Do you recall talking to Lori and Chad on a phone call on that day?
I don't I know we had a phone call with them. I don't remember the specifics of it.
Okay.
It's been a few years.
And it may not have been that particular day that he died. It may have been the day after. Is that right?
It may have been, yeah.
Okay. And in that conversation, do you recall whether or not Melanie was, what was going on that particular day when you found out that Alex had passed away?
From what I recall, Melanie had been told by Chad and Lori to go to a place of safety. Mm-hmm. So she went to my apartment. Melanie was at my apartment. She went up to the temple in Rexburg, and that's about as much as I can remember.
So you were in Rexburg, and she was in Rexburg.
Yeah.
And is this a time when you secretly recorded her?
Yes.
Okay. And she didn't know she was being recorded?
No.
And they had put it on speakerphone, do you recall that, or no?
The recording on speakerphone?
Yeah. The phone call that she was on?
Yeah. Sometimes when they would talk, yes, it would be on speakerphone.
Okay. And do you recall whether or not Chad and Lori gave Melanie a comforting blessing that day?
I don't remember if they did or not.
Okay. You were making these recordings and then turning them over to law enforcement, is that right?
Yes.
Okay. And what was the purpose of making these recordings?
We were trying to find out if there was, we were trying to either obtain some kind of evidence. I didn't know what the FBI knew, and I was hoping, we were both, I guess the mutual hope was that we would get anything that we could use to help find Tylee and JJ.
Okay. So you went to the police or to the FBI?
I went into the Rexburg Police Department initially.
And they contacted the FBI?
The FBI was present when I arrived.
When you arrived. Okay. And how many recordings do you think you did?
I believe there were 9.
9 recordings?
Mm-hmm.
And did you listen to these recordings with the FBI after they've been recorded?
I've heard bits and pieces of them. I haven't ever listened to them all the way through.
Okay, when you say you've heard bits and pieces, how does that come about? They just call you in and ask you to listen to this and see if you can interpret?
No. So I've actually never listened to them with law enforcement. It's always been in the context of leading up to this trial. So it's the last time I listened to recordings was when we were summoned to the grand jury to indict Lori. Mm-hmm. And we had some brief snippets that we listened to. There was probably a grand total of maybe 10 minutes total that I heard.
Okay. And what kinds of things were in those snippets?
There were snippets with discussions between Melanie and I, and there was a phone call with Chad, Lori, Zulema, Al, and Melanie present.
And what were those recordings about?
I was questioning, I was asking questions to Melanie. I was trying to figure out what she was hearing, what she was understanding. I was also trying to, another recording was the one with everyone present was At that time, Melanie was sick. And so she was just calling to talk to her aunt. And everybody just happened to be on the phone call. And so they started, the one thing that stands out was Lori said she folded Satan up like a taco and sent him to Antarctica. Lori said that she was able to cast Satan out by folding him up into the shape of a taco and locking him in a box in Antarctica.
Okay. And did that make any sense to you at the time?
Nope. They were talking about spiritual attacks coming soon, that things were going to get difficult for about 2 weeks, and then everything would settle and be okay. Mm-hmm. And this was, I think that was a recording I made in December 6th.
Okay. And so you don't have any you have specific recollection of the December 6th recording about something that Lori said, but you don't have any specific recollection of a blessing that was given to Melanie?
No, I gave Melanie a blessing.
You gave Melanie a blessing?
When Al died, yeah.
On the 13th?
I don't know.
12th or 13th?
It was 12th or 13th, yeah. I just gave her a blessing of comfort.
Okay. And was that when Lori and Chad also were on the phone?
No, they weren't on the phone at that point.
They weren't on the phone. But you don't recall ever being involved in a blessing with Chad and Lori?
No, I don't recall.
Do you think that there was no blessing with Chad and Lori?
No, it's very possible. I mean, blessings were flying around like flies.
What kind of blessings?
Blessings of guidance, comfort, to remove dark weapons. I mean, when I called and talked to Chad and Lori to ask their hand in marriage, Chad gave me a blessing, and he removed all dark ties from me, and he removed dark weapons from me, and he shielded me with light, and there were just, lots of different things that he was saying. So at any time there was any kind of negativity or difficulty, there was almost surely a blessing that would come at some point.
So Chad and Lori weren't giving these blessings in like a dark way. They were trying to raise you up to a higher level. Is that right?
Yeah, that's how it came across at the time. Yeah.
At the time, does it come across differently now?
I mean, given the context of it, I mean, given everything that's happened since, it feels a lot more like manipulation than it does, true intent to help.
You feel like you were manipulated?
Absolutely. More than anything, I feel like Melanie was manipulated and taken advantage of in one of the most difficult and dark times in her life.
And difficult and dark times, what are you talking about?
She was going through a rough divorce. Her children had been taken from her. This case was there's no shortage of people in Melanie's life that will abuse her and her circumstances to get what they want out of her. And Lori was one of them.
And it's your understanding that Lori was trying to get something out of Melanie?
That's what it looks like. I haven't ever seen any hard evidence of that, but in the investigations and discussions I've had with law enforcement, with attorneys, everything that's come since, it really looks like there was something to be taken from Melanie.
Let's talk about that. What kind of manipulations, what kind of interactions have you had? You seem to not really have a lot of interactions with law enforcement, and not have a lot of recollection about those interactions with law enforcement. So let's talk a little bit about that. What are you talking about?
Objection, that's argumentative.
Well, that was an argumentative comment, Mr. Thomas.
All right. What kind of interactions have you had with law enforcement that you've gained where you believe that Lori has been manipulating Melanie specifically?
So there's been, in the times, in the 2 weeks that I was meeting with them, there were a lot of things that came about that didn't look like Lori was exactly being truthful with Melanie.
What was she manipulating Melanie about in those 2 weeks?
She was telling her, that Brandon's dark, that law enforcement officers that Melanie should have been cooperating with were dark, translated beings, that they were out to get them, that they were impeding their holy mission. When in reality, these officers were trying to find 2 missing children, find out what had happened with the shooting of Brandon Boudreaux.
So Lori said that you were dark.
Lori never said I was dark, no.
You said Brandon was dark. Oh, Brandon, her husband, Brandon Boudreaux.
Correct.
Okay. All right. And, okay. All right. But they never said anything poor or bad about you?
No, they did not.
And you recorded all those conversations so you would know, right?
Right.
Right. If I could have just a second, Judge.
Yes.
Your Honor, based on his purported lack of knowledge of what is recorded on December the 12th or December the 13th, we'd ask that he listen to what has been marked as Defendant's Exhibit F to refresh his recollection of that recording that he purportedly made on that date.
Your Honor, we would request a sidebar.
Very well. All right, counsel, we had a sidebar discussing the request that the witness be allowed to refresh their recollection with a recording. Based on the sidebar, the court is denying that request at this time, and you can continue with your examination, Mr. Thomas.
Thank you, Your Honor. So specifically with this Alex Cox passing, this was a big deal for Melanie, correct?
Yeah, absolutely.
She was very close with Alex?
Yeah.
Alex was her uncle?
Yes.
And when this happened, were you there when she got the news?
Yes.
How did you hear about that?
Zulema called and told Melanie.
Zulema called and told Melanie?
Mm-hmm.
And you were there for that phone call?
Yes.
Okay. And then at some point, Melanie called Lori and Chad, is that right?
Yes.
And that particular phone call was recorded by you?
Yes.
Okay. And were you trying to record all the phone calls that that Melanie had with Chad and Lori?
As many as I could without, being too obvious. I mean, there were some conversations where, for me to just walk into the room and stand around, it would have been really awkward and, just unnerving to her. Not unnerving, but just it wouldn't have felt appropriate for me just to show up and stand around and just hang out until she's off the phone. So I got as many as I could where it felt appropriate.
Well, on this particular occasion when Alex had died, Melanie was quite distraught, right?
Correct.
And she was crying?
Yes.
And she felt like she had been attacked by spiritual demons or whatever?
Yeah, I mean, so that's how she had been told by Chad and Lori that there was going to be a spiritual attack that day to get to a place of safety, and with Alex dying, that confirmed that.
And on that particular day, did you feel like that was something that she was actually being led to, or is this something that she was being manipulated?
I have no clue how Chad and Lori could have called that Alex was going, or not that Alex was going to die, because they never said that specifically, but that there was going to be something bad happening, that there was going to be a heavy spiritual attack. When Alex died, it felt very strange to me that they'd called that out right before it happened. I think everybody at that point was grieving it. That's Lori's brother.
So,
somebody that she loved and cared about. So I think everybody was hurting. It's Zulema's husband, Melanie's uncle. I think everybody's genuinely hurting. So if, at that point, if there is any manipulation, it's kind of already been, the groundwork's already been laid for it. I don't think there is any active attempts at manipulation at that point.
So there was no manipulation on that particular aspect?
I mean, like I said, there was groundwork laid for it, with all of the spiritual, I guess the best way I can explain it is, there's reality, and then there's the layers of spiritual explanations that were laid over reality. And that's, at that point, I don't think Lori was pushing to manipulate that particular event to hurt Melanie.
So she wasn't manipulating, you thought that was a spiritual event?
I didn't believe that was a spiritual event, but I don't think Lori was trying to manipulate Melanie.
You don't believe that Chad and Lori giving Melanie a blessing over the phone was a spiritual event?
Well, no, I mean, I guess in that context, yes, it was a spiritual event, yes. But I don't believe there was a spiritual attack that killed Alex.
No, right. But Melanie said she was... Did Melanie say anything about her being feeling spiritually attacked or feeling...
I don't specifically recall her saying that. I'm sure I could imagine at that point, yeah, she did. But I don't specifically recall anything that she said.
Okay. Do you recall Chad and Lori putting shields of light around Melanie when they were giving her this blessing?
That sounds like something that they would do, but I don't remember it specifically.
You don't have any specific recollection?
Right.
Okay. And how many times, you indicated that you recorded these 9 recordings in about 2 weeks, right? Mm-hmm. Okay.
Yeah.
And how many times were there spiritual blessings in those recordings?
There were just a handful that if I remember correctly, there weren't very many.
Mm-hmm.
I mean, well, yeah, I think there were a handful of them that were done over the phone.
And were you ever brought into those blessings?
Yeah.
So you also were blessing Melanie at the same time?
If I remember correctly, there may have been, I may have done that at some point. I know I gave her a blessing the day that Al died.
Okay, but specifically when Chad and Lori were giving her blessings, were you ever called in, and did you ever lay hands on Melanie's head when they were giving a blessing?
I don't remember specifically if I did, but based on how blessings were given, the way they organized the blessings, that's absolutely something I could have done.
So you're saying you don't ever remember putting hands on Melanie's head while Chad and Lori talked over the phone and the three of you gave her a blessing?
I don't specifically remember it, but if you told me I did it, I'd believe it.
You don't specifically ever remember doing that?
No.
Objection, Your Honor. This has been asked and answered multiple times now.
Sustained.
All right, Judge, we have no further questions.
All right, thank you, Mr. Thomas. Redirect from the state.
No redirect, Your Honor.
All right, any objection to the witness being excused?
No, Your Honor. We would ask that he be released.
Any objection from the defense?
Your Honor, we may call him in our case in chief, so yeah, we're not going to allow him to be released.
Your Honor, we would ask that he be released from the state subpoena.
And Judge, given the, I'm sorry, may I speak?
Go ahead.
Given the posture of Mr. Pawlowski, we'd ask that he is unlikely to come back should we need him to come back. So we'd ask that he not be released from this subpoena.
And Your Honor, I would just indicate there doesn't appear to be any hesitation on Mr. Pawlowski's part to be here today. If the defense wants to bring him back, I think they could.
All right, well, the court's not aware in the file of who has placed Mr. Pawlowski under subpoena. Is it the state only?
We have a subpoena. I cannot speak for the defense, but the state has a subpoena, and we would release him from our subpoena.
All right, here's what I'll do. I'll allow Mr. Pawlowski to be released from the state subpoena. However, I will direct you that before you leave, that there be an opportunity, if the defense wishes to recall Mr. Pawlowski in order to ensure his attendance, that they be provided an opportunity to serve a subpoena.
Thank you, Your Honor.
And I'll authorize one on short notice if required. Perhaps during the break you can discuss that issue with Mr. Pulowski and see if there's any assurance that he'll appear and whether or not you need to go through the step of placing him under subpoena.
Very good, thank you.
All right. So you can go ahead and step down. That concludes your testimony at this time, Mr. Pulowski.
Your Honor, I apologize for interrupting. Mr. Pulowski is here with counsel out of Arizona. His counsel indicated to me that he is willing to accept service, that Mr. Pulowski would be willing to come back under that subpoena from the defense. If that is, in fact, their intention, he will accept service.
Okay. Thanks for that information as well then, Ms. Blake.
Sounds good.
All right. Is the state ready to call its next witness?
Yes, the state will be calling Taylor Ballard.
Very well.
Solemnly swear or affirm that the testimony you're about to give will be the truth, no truth, and nothing but the truth, so help you God.
All right. Now that the witness has been placed under oath, let me just inquire briefly. Have you viewed or listened to or in any way been advised of the testimony that has taken place in this trial since it started?
No, sir.
Okay. With that in mind, then, you can go ahead and inquire on direct. Ms. Rawlings, I'll indicate to the witness, please make verbal responses to any questions asked of you and try to avoid speaking at the same time as any attorney questioning you so we keep a clear record. Ms. Rawlings, you can conduct direct.
Thank you, Your Honor. Good morning. Could you please state your name and spell it for the record?
Taylor Ballard, Taylor Ballard.
And Ms. Ballard, how are you employed?
I'm a health insurance broker at Ballard Insurance Group in Rexburg, Idaho.
In your role at Ballard Insurance, did you have a client by the name of Chad Daybell?
Yes.
Can you tell us about any contact you had with Chad Daybell in October 2019?
I met Mr. Daybell on October 31st, 2019. He came into my office to inquire about obtaining health insurance for a November 1st effective date because the coverage that he currently had through his wife's employer was expiring that day because she had recently passed away.
So that was for individual health insurance?
Yes.
Did he seek health insurance for anyone else?
For his children, Seth, Leah, and Mark.
And did you have a conversation with him about how he was going to get the insurance on that day?
Yes.
Briefly, what was that conversation?
At the time, Idaho was looking to expand Medicaid to adults beginning January of 2020. And so he made a comment that his income for 2020 was going to look different now that he didn't have his wife's income. And so I told him he was a possible candidate for Medicaid beginning January, and so we just needed to cover him and the children for November and December of 2019.
Okay, and did you have any contact with him following up on his request for that individual health insurance?
Yes. On that same day, I had told him that we don't normally apply people for Medicaid because it's no benefit to us, but given the situation, the nature of his situation, and his wife being a previous client, I told him that I would apply him for Medicaid for January, and we got the coverage for him and the kids November and December. And so on November 5th, I went to Health and Welfare to apply him for Medicaid for January. And the Health and Welfare interface looked up previous income information and saw that the income number that I had given them from him was higher in their records. And so they said that he would not qualify for Medicaid, but rather a tax credit through the individual market. And so I would need to get him individual coverage in January instead of Medicaid. So I texted him on that same day asking him if he could bring me a copy of his, do you know what? I have my dates wrong. I'm so sorry. On November 5th.
I'm going to object here. I think this is a narrative. I just asked that there be a question asked.
I will sustain that, so let's start over with a new
Okay.
question, if you don't mind, Ms.
So
Rawlings.
Thanks, Taylor. Let's talk about after you checked on his income with Health and Welfare, what was the next contact that you had with Mr. Daybell?
Yes, I'm so sorry. So on November 5th, when I went to Health and Welfare, the income situation, they told me, they said, we think we've got too high of income in here. And so I took...
Object to hearsay, Judge.
I'll sustain that.
What ultimately did you learn and what did you do after going to Health and Welfare?
That he possibly would not qualify for Medicaid, so Health and Welfare asked me to retrieve a copy of his tax return. So I texted him on November 5th asking if he could bring me a copy of that.
Okay. So you reached out to him by text.
Yes.
Did you hear back from him?
Yes.
What communication did you have from him?
He responded and said that he was out of state all week, and so he couldn't, and so he would bring me the tax return possibly the following week.
Okay. And did you hear from him again?
Yes.
When was that?
He brought his tax return in at some point. I did not visit with him that day, but I took the tax return to Health and Welfare, and based on that information, they found that he did not qualify for Medicaid, but rather the tax credit that I was saying before. I got mixed up. I'm sorry.
No, that's fine. Did you have a conversation with him later in November about the other forms of insurance that were available?
Yes. November 21st, I texted him and asked if he could come into the office so we could talk about those options.
Okay. And what conversation did you have with him at that time?
He did come in, and I showed him the options for 2020, and then it was just going to be for him and his son Mark at that point in January. And then he asked me that if he were to get married, how hard it was to add his wife to his policy.
Okay. So he inquired about someone else?
Yes.
What was your response to that?
I told him that it wasn't a problem to add a spouse, but we'd need to do it within 60 days of the date of marriage.
Okay. Did he indicate anyone other than this potential new wife would need coverage at that time?
Just his son, Mark.
Okay. And was there anything more about the needs of him or his wife on this November 21st date that you discussed?
No.
Anything more about the insurance coverage on the 21st that you can remember?
I just told him that I would email him the options, and he could pick which and let me know which plan he wanted.
Okay. And did you hear from Chad again?
Yes.
When did you next hear from him?
I'm sorry, can I look at my notes?
Your Honor, this witness had prepared some notes in reference to her interactions with the insurance, and she has them here. I'd ask that she be able to review them to refresh her recollection on the dates.
Okay, they'll need to be reviewed by defense counsel first, please.
It's just the one in the clasp is all I want.
I'm sorry. Your Honor, may I aid in an objection to her reviewing these notes? May I volunteer an aid of an objection?
You may.
Ms. Ballard, it looks like there's about 15 pages of text writings that have some footnotes in there. Is that my understanding?
Yes.
And it looks like it's a day-by-day, play-by-play type of encounters with Mr. Daybell. Is that right?
Correct.
Okay. Is this something you do in the normal course of your business, or was this something that was asked of you by law enforcement?
I was subpoenaed to provide that information.
Okay, and you provided that information to law enforcement?
Yes.
Okay. If I could have just a second, Judge, to confer with counsel.
Yes.
Judge, can we just have a quick sidebar?
Yes. All right, there's been a request to have the records used to refresh the witness's memory. They've been reviewed by counsel. I don't know, were they supplied to the witness at this point?
Not yet, Your Honor.
Okay, they can be at this time.
Thank you.
And so, Taylor, just to refresh your memory, we were discussing, my question was when you heard from Chad again after the November 21st conversation.
Yes. He reached out to me on...
Let me stop you.
I'm sorry.
So you're going to be allowed to look at your notes to refresh your recollection, and then you'll have to close them and testify. It's just to refresh your memory.
Okay. He reached out to me on December 10th, and by phone call, and I responded to him on the 11th.
Okay. And I want to just clarify a couple things about the notes and what you provided to law enforcement, if I can. You, as an insurance agent, have a file on your clients. Is that accurate? Mm-hmm. Did you provide the insurance file or the insurance information to law enforcement?
Everything that I had on Mr. Daybell I gave to.
Okay. Did you make personal notes for your own memory and to be able to recall your interactions with him?
No.
No? Okay.
Your Honor, at this point, I'm going to make an objection that there is a discovery violation. This witness has turned things over to the state that we've not been in possession of.
Sidebar, Your Honor.
Go ahead and finish your
We
objection.
cannot adequately cross-examine her without the information that has been provided to the state. So I would object to her being called as a witness, and I would ask that she be excused.
Well, I'm not going to go that far with the objection at this point. There's been a review of the file made by defense counsel. I guess it's raised an issue which we may or may not need to take up outside of the presence of the jury. Let's have a quick sidebar on that issue, counsel. All right, thank you. At this point, there's been an issue raised as it relates to the file and whether or not it's discoverable evidence in the case. It's been argued to some extent by the defense. The court's going to make an in-camera review of the file to determine whether or not we need to proceed any further with that issue. In order to do that, we'll take the mid-morning break at this time, and we will reconvene at about quarter till the hour and continue with the direct examination.
All right, please.
Thank you. Please be seated. Okay, we're back on the record on CR 2221-1624, State of Idaho versus Lori Vallow. We had an issue come up with an objection as it related to the file notes of this witness. There was a question, I think, of whether or not discovery had been produced, and as I understand at this point, the parties have resolved that issue. Is that correct, Ms. Rawlings?
That's correct. We were able to provide the Bates number to the defense for where this information was provided.
Okay, and so that takes care of the objection then, Mr. Thomas.
Yes, Your Honor. It looks like it may have been provided to prior attorneys prior to Jim and I coming on, but we don't remember seeing it. But we know that it was Bates stamped, and it is in our discovery.
Okay, with that in mind, then I'll just indicate, because of the nature of the objection made in the presence of the jury, I'm going to provide a curative instruction for the jurors once they come in and remind them that the evidence is to only be considered and that arguments on admissibility of exhibits are not to be considered. So we'll take care of that once the jurors are returned to the courtroom.
Thank you, Your Honor.
Thank you, Judge.
All right, so, and you have the file back? Okay. Let's go ahead and have the jurors return then, please, Mr. Bailiff.
And let's wait it.
All right, please. Jury's out, President, count for your honor.
All right, thank you, Mr. Bailiff. Please be seated. All right, we are back on the record in this matter. Ms. Ballard is still on the stand with direct examination. Ms. Rawlings conducting that examination. Before we start again, I just want to advise the jurors there was a defense raised by, or an objection raised by the defense prior to the break. We've resolved that issue, and I wanted to just remind the jurors, you may or may not remember on the first day of trial you were given a bunch of instructions, and you'll still be getting those later. Among those instructions is an instruction that states specifically, and I'll quote, "At times during the trial, an objection may be made to a question asked a witness or to a witness's answer or to an exhibit. This simply means I'm being asked to decide a particular rule of law. Arguments on the admissibility of evidence are designed to aid the court and are not to be considered by you nor affect your deliberations." So please keep that in mind as it relates to that objection, and I would ask you to disregard it as it does not relate directly to what you will consider as evidence in your deliberations. So with that in mind then, Ms. Rawlings, if you'd like to continue with your direct, you can do that.
Thank you, Your Honor. Taylor, do you remember we were discussing, I believe, a phone call that you had with Chad in December 2019?
Yes.
And what can you tell us about that conversation?
He called me because he wanted to make sure to pay his premium for January, and I had told him that I never heard back from him from the email that I sent him with the quotes. And so we briefly went over those options, and he picked a plan and paid for his premium.
During this conversation, did you discuss coverage for anyone other than him at that December call?
Only his son, Mark.
Okay. And did you hear from Chad Daybell again later?
Yes.
When did you hear from him?
I believe it was March 11th, 2020. He came into my office.
What did he want when he came to see you on March 11th?
His original inquiry was to obtain health coverage for his new wife.
Okay. And can you tell us about that conversation?
He told me that he'd gotten married and wanted to get coverage on his new wife. And I asked him when they got married, and he told me that it was November 5th, 2019. And I told him that we were outside of the 60-day window, so that wouldn't be possible. And
Okay. Did you discuss what other qualifying events there might be?
yeah, he told me that she was incarcerated and he was really worried about something happening to her, but that she was supposed to be getting out the following week. And so I said that that's a qualifying event.
Okay. Did you discuss other qualifying events?
Yeah, we talked about moving back to, moving into a state is a qualifying event, or losing coverage elsewhere.
Okay. And when you talked about moving into another state, did you discuss with him where he and his wife had been previously?
Yeah, he told me that they were living in Hawaii and that they had just come back to Idaho.
Okay. Did he ask about coverage for his wife, including dental insurance?
Yes.
And he asked about coverage for his son, Mark.
Yes.
Did he talk about anything else relating to the background of his wife, what her needs would be?
No.
Okay. So let me just break this down a little bit. He talked to you in November about possibly getting married again, right?
Yes.
At that time, he did not ask for coverage for anyone else, though.
Correct.
Okay. Did he tell you back in November anything about this potential new wife?
Yes.
What did he tell you?
He told me that she lives in Kauai, and so that they would live there half the year and in Idaho for half the year. He told me that she was a widow and she lived off her husband's Social Security death benefits.
Okay. And so fast forward to March, the March visit, when he was trying to get the insurance, did you ask him if you could double check some information?
Yes.
Okay. Did you notice anything else about Mr. Daybell between your visit with him in November and your visit with him in March?
Physically, I just thought he looked thinner and tanner, which made sense if he'd been in Hawaii.
Okay. Did he tell you who his new wife was?
Yes.
What did he say?
He wrote on a sticky note, Lori Daybell.
And did he indicate whether there was coverage needed for anyone else?
No.
Did he state whether or not she had any kids?
No.
No, he didn't state it, or?
I went through the application process like I would with anybody, just verifying, is this your phone number, is this your address, etc. And one of the questions is, are there any children? And when I asked that, he said no.
Okay. If I may have just one moment, Your Honor.
Yes.
I don't have any other questions at this time.
All right. Thank you, Ms. Rawlings. Mr. Thomas Cross?
Thank you. Yes. Morning, Ms. Ballard. You had filled out some information for Chad to present to the Department of Health and Welfare. Is that correct?
Yes.
And some of that information, I think you said, was had to do with his income because he may qualify for Medicaid.
Correct.
Okay. And what was his income?
I think, I don't remember, this is a long time ago, but I think at the time he had said that his income without his wife's would be around $20,000.
Okay. I went through your notes, and would it refresh your recollection if you went through your notes and looked at that particular?
Definitely.
Okay. Can we give that to her?
And again, I'll just advise the witness that if you're using those to refresh your recollection, don't just read from the notes, but look at them and then close the file once you've done that.
Yes, sir.
And just to kind of speed things along, there's an actual piece of paper that's from Health and Welfare that's attached to those notes or inside that packet.
So Chad told me that they wouldn't have any income, and then Health and Welfare System interfaced $30,000.
$30,000?
Yes.
That was his income for the year?
That's what he was, yeah. Mhm.
Okay. Thank you. No further questions.
All right, thank you, Mr. Thomas. We'll have well, let's see if there's any redirect. Ms. Rawlings?
No, Your Honor.
Okay, without any redirect, then can this witness be excused?
Yes, we would ask that she be released.
No objection.
Okay, you can be excused. Make sure to take your file with you. State can call its next witness.
State will be calling Angela Yancey.
Swear or affirm that the testimony you're about to give will be the truth, full truth, and nothing but the truth, so help you God.
All right, before we get started with testimony, let me just inquire of the witness, Ms. Yancey, have you reviewed or listened to or read or in any way seen any of the trial testimony in this matter since the trial started?
No.
Okay. As you testify, please talk right into that microphone so your voice is picked up clearly. Please make verbal responses to questions being asked and try to avoid speaking at the same time as anyone questioning you. With that in mind, Ms. Rawlings, you can inquire.
Thank you, Your Honor. Good morning.
Good morning.
Would you please state your name and spell it for the record?
Angela Yancey, ANGELA YANCEY.
Angela, where were you employed in 2019?
Sugar Salem School District.
How long did you work there?
7 years.
What was your job title?
I was the payroll and benefit administrator.
And what were some of your job duties with regard to that position?
I processed payroll for all of the employees, and I assisted with all of their benefit administrations.
Was it part of your job to process employees' insurance applications?
Yes,
And this would have included life insurance.
correct.
Are you familiar with Tamara or Tammy Daybell?
I am.
Do you know if she worked for the Sugar Salem School District?
Yes, she did.
What was her job?
She was the elementary librarian.
And I think you mentioned you processed benefits for employees. As part of that, did you run benefit meetings for the school employees?
Yes, every year during open enrollment, we would go to each building and hold meetings that informed them of any changes to their benefits, and we brought forms if they were to make any changes.
So you informed them of any changes. Would you also discuss open enrollment periods, life insurance changes, that type of thing?
Yes.
And when would the open enrollment period be for the school district?
It started in August, excuse me, and they had until the middle, about the 12th to the 15th of September, to get the applications back to us to be effective as of 9/1.
And what types of forms did you provide to the employees at these meetings?
Change forms for their medical, dental, vision, life.
And do you recall if Tammy Daybell made a change to her life insurance policy in 2019?
She did.
Do you know if she submitted an application for that change?
Yes, she did.
Did you process that?
I did.
If I were to show you a document purported to be part of that, or the application or part of that, would you be able to recognize it?
Yes.
And Your Honor, I will be asking to have States Exhibits 151, 152, and 153. These have already been admitted, but I'd like to publish them for the jury so that the witness can reference them.
Okay.
And Your Honor, may I have permission to publish so the witness may reference?
You may.
Easier to read. Oh, goodness. I think it's more like, is it easiest to read that way?
Yes.
Okay. Do you recognize what's been marked as States Exhibit 151?
I do.
What is that document?
This is a change form to her voluntary life insurance.
And do you know, when you say change form, is that a different application than had been previously made?
Yes. When she was originally hired, they when I present the life insurance, voluntary life insurance to them, they can elect a minimum of $10,000. And so that would have been her original form. And then the way the benefits worked is any time after that during open enrollment, you can increase it.
Okay. So this was a request to increase. Do you remember when she was hired?
I believe in 2017.
Okay. And do you know what the amount of life insurance was on that 2017 application?
She elected the minimum of $10,000.
And in 2018, did she make any changes or request any changes?
She did not.
So then in 2019 on this document, she requested to increase the policy.
Correct.
And did you process that paperwork?
I did.
Who signed that request for the increase in benefits on her application or the change form?
Tammy did, and because she elected spouse coverage, her spouse also signed it.
Okay. And would that be on a different page than this first page?
Yes.
And when was this form signed and dated?
September 8th, 2019.
And then the form would have to be turned into your office, is that right?
Correct.
Okay. What date would the increase in the life insurance have gone into effect?
9/1.
Okay. And so what was the total amount of the life insurance policy for Tammy Daybell once this change went into effect?
So she elected the max, which was 5 times her salary at the time, so it was $80,000, and then she also had a $50,000 from the group life.
Okay. And were you involved in, or did you assist in a claim being submitted with regard to collecting on her life insurance policy?
I was.
I'm going to show you what's been marked and admitted as State's Exhibit 152. If I may, Your Honor.
You may.
And do you recognize that document?
I do.
What is the title of that form?
It's a beneficiary statement.
Who submitted the beneficiary statement form?
Her husband, Chad.
And did you meet with Chad Daybell when he provided that form? Or provide him with that form, excuse me.
I did.
Do you recall when you first met with him?
He came into my office Monday morning after Tammy had died. So she passed away between Saturday and Sunday, and he was there Monday morning.
And I want to back up a little bit. You had said you worked in HR for the Sugar-Salem District since 2013, is that right?
Correct.
Where did you work before that?
Madison School District.
And were you responsible for helping employees of both school districts process life insurance claims?
I was.
How many times would you say you have assisted with processing life insurance claims?
I'd say roughly 15 or so.
And so you said that Chad came in on October 21st, which was the Monday after Tammy had passed away. Mm-hmm. And in your experience, was it unusual for a spouse to come in that soon to process a life insurance claim?
In my experience, yes.
What conversation did you have with Mr. Daybell when you provided him with the form on October 21st, 2019?
I explained to him that we could not submit a life claim until we had the original death certificate to go with it. And he said, that's okay, I've already ordered 8 of them.
And in your experience, how many death certificates do most people order?
When they share that information with me, I've heard maybe 3 at the most.
And do you know when Chad returned to submit this beneficiary statement?
He returned on October 25th. I was out of town, and so my coworker told him that he would need to come back on the 30th when I was back in town, and he was there on the 30th.
And who fills out the information that's contained on that beneficiary statement form?
Chad did.
So the information regarding attending physician and such is filled out by the spouse typically?
Correct.
And drawing your attention to the notation that she died in her sleep, would that have been filled out by Chad Daybell before bringing the form back to your office?
Yes, it was.
Now I'm going to show you what's been marked as State's Exhibit 153. And do you recognize this?
I do.
What is the title of this form?
It's the employer's and/or administrator's statement.
And who fills out that form?
I did.
And so you recognize this as the form that you filled out?
Yes.
What did you do after Chad had brought in the beneficiary statement?
I completed this statement and then attached the death certificate and submitted it to the life insurance claim or company.
And so when would you have filled out the form?
I did it that day that he brought it, the 30th.
Brought in the death certificate? Mm-hmm. Okay. Now we talked about the increase in life insurance that Tammy had requested in September. What's the amount of life insurance on this form, if you can see it?
It says $50,000 for the basic, which is the group life, and it says $10,000 for the voluntary. Her change form had not been filed in her file yet, and I used the information from her file.
So you didn't have the change or the updated or the increased information?
Correct. But it had already been submitted to the insurance company, so they had the correct information.
And so what was the correct amount?
$80,000.
And so what was the total amount that would have been paid out for this life insurance claim?
$130.
And do you know if that's the maximum amount that could have been requested for an employee in Tammy's position?
Yes.
I don't have any other questions, Your Honor.
All right, thank you, Ms. Rawlings. I got a few things. Cross-examination.
Thank you, Your Honor. So there were a few different life insurance policies on Tammy, is that right?
With our school district, there was only 2.
Okay. One of them was the group insurance, right?
Correct.
All right. And that's offered through the school district as a free bonus for every employee of the school district, correct?
Every eligible employee, yes.
Any eligible employee is somebody who works full-time.
Correct.
All right. So if you're a full-time employee, you don't really have to fill out anything. It's just part of your package, your benefits package.
Correct. There's not an enrollment form. We just require a beneficiary form.
Okay. And in this particular case, the beneficiary was Chad Daybell.
Correct.
And she indicated that Chad Daybell would be the beneficiary.
Yes.
And he didn't come in with her to fill out that beneficiary form to your knowledge?
Not to my knowledge, no.
Okay. So the $50,000 was offered to every employee. So now we're going to the $80,000. The first year when she enrolled was a $10,000 enrollment, the bare minimum you can get, right?
Correct.
And I believe, if I'm correct, and I'm probably not, it was somewhere around $1.93. Was that a paycheck or a month?
Well, the school district pays monthly, so
Okay.
it'd be the same.
So it'd be $1.93 a month
Correct.
with a $10,000 life insurance.
Correct.
All right. And then I believe the $75,000 one had something around $15 a month. Is that right?
I don't know the exact amounts. It's done by age, so whatever her age was at the time
Okay.
is what it is. But
On the form that, I guess we can bring up let's bring up the last 2 exhibits, State Exhibit 153 and 152. I'm sorry, I'm gonna have you look at 151. Can you read that okay?
I can, yes.
All right. So we were just talking a little bit about the $10,000 one, and it is what, $1.98 a month? Is that right?
Yeah. It's a little blurred, but that looks right.
Okay. And then the $75,000 one would be how much?
$14.70.
$14.79, or is that 70? I'm like 70. You're right. My bad. $14.70, and then $80,000 would be a little more than the 75,
Correct.
right?
Right.
Okay. And so in your work, that this is part of your work, is it often? What is your experience with how much people normally get? Do they normally get the maximum?
It all depends on the individual and what's going on in their life. We just explained that if they initially elect the $10,000, then anytime in the future they can elect up to their 5 times their salary. And so it just depends on the individual.
Okay. And that open enrollment is only one time a year?
Correct.
And it's about a 30-day period?
Correct.
And in this particular date, it was when, August to September, or when was it, do you remember?
For a school district, yes. We started in August when they come in, when the employees come back to work, and then they have until about the 15th. It's a grace period in September, but it's still effective 9/1.
Okay. So this was within the grace period?
Yes.
Okay. Thank you. No further questions.
All right, thank you, Mr. Thomas. You redirect.
I don't have anything, Your Honor.
All right, can the witness be excused?
Yes, we would ask that she be released.
No objection.
Okay, that'll conclude your testimony. Thank you for appearing. The bailiff will assist you leaving the courtroom. State can call its next witness.
The state will be calling Colin Nesbitt. Ms. Smith will be questioning him.
Thank you.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay, thank you.
All right, before we commence with testimony, let me just inquire of the witness. Officer, have you reviewed in any way any of the trial testimony in this case, including reading it or hearing it from any source?
No, sir, I have not.
Okay. As you testify, please talk directly into that microphone, use verbal responses to any questions asked, and please avoid talking at the same time as anyone questioning you so we keep a clear record. With that in mind, Ms. Smith, you can inquire on direct.
Thank you, Judge. Good morning.
Good morning.
Can you introduce yourself to the ladies and gentlemen of the jury and spell your last name for them, please?
My name's Colin Nesbitt, and it's spelled Nesbitt.
Sir, how are you employed?
I'm employed with the County of Kauai Police Department in Hawaii.
How long have you been a police department in Kauai, Hawaii?
16 years.
What is your current position?
I'm a detective with the Major Crimes Section.
And how long have you been a detective in the Major Crime Section?
4 years.
And prior to that, what was your role?
Prior to that, I was a detective in the Property Crime Section for 2 years, and then I was in Narcotics Section for a year and a half.
Okay. And what sort of training have you had as a police officer in Kauai?
I've had the basic academy training. That's approximately 5 months long. And then I've had additional training, approximately about 400 hours. Approximately 200 of that would have been in major crimes, such as sex assaults, homicides, death investigations, and robberies.
And so in your role as a major crimes detective, did you have occasion to work and have contact with Lori Vallow?
Yes, I did.
What was your contact with Lori? What was your first contact with Lori Vallow?
My first contact with Lori Vallow was January 25th, 2020.
Okay. What caused you to come in contact with Lori Vallow in January of 2020?
I was assisting members from the Rexburg Police Department to serve a legal document.
Okay. And how was it that you came to be a part of assisting Rexburg, Idaho police officers in serving legal documents on Lori Vallow?
Oh, well, they all flew over to Kauai for whatever their investigation was into the matter, and then we had an operational briefing, and they asked for assistance to help locate and serve that document.
Okay. And was Lori Vallow, and there's water there if you need it.
Yes,
okay.
Thank you.
I'm assuming, given your answer, that Lori Vallow was located?
Yes, ma'am.
Where was she located?
She was located at the address of 4141 Queen Emma Drive in Princeville, which is a condo complex, and she was in the swimming pool area.
Okay. Who was with her?
Chad Daybell.
Okay. And who went up to serve her those legal papers?
Detective Cataluna served those the papers.
Okay. Who was present from law enforcement when Detective Cataluna served those papers?
Also with Detective Cataluna was Lieutenant Christopher Collio and myself.
Okay. Were you with the detective and the lieutenant the entire time that they went in to serve the papers on Lori Vallow?
Yes, ma'am, I was.
Was that service recorded in any way?
Yes, it was.
How was the service of papers on Lori Vallow from Idaho, those papers from Idaho, how was that service completed?
She was provided a copy, and then she was asked if she had any questions.
Okay. And after that happened, was that recording captured and saved?
Yes, ma'am, it was.
And were you the person responsible for making a copy and saving the recording of the service on Lori Vallow in Hawaii?
Yes, I was.
Okay. And did you make a copy and turn it over to anyone?
Yes, I did.
Who did you turn it over to?
The Rexburg Police Department.
Okay. And prior to coming to court today, did you make another copy for use in trial of that recording of service of papers on Lori Vallow?
Yes, ma'am, I did.
Okay. And did you put it on a thumb drive and mark it with your initials?
Yes, ma'am.
Your Honor, I'd ask the court that the court hand Officer Nesbitt State's Exhibit 205.
You may be.
Thank you. And I apologize. I think I called you officer. It's detective, right?
Either one is fine.
Okay. Detective, do you recognize State's Exhibit 205?
Yes, I do.
Okay, what is it?
It's the thumb drive that I saved a copy of the recording on.
Okay. And did you prepare that thumb drive?
Yes, I did.
Is it, other than the recording of the service of paper on Lori Vallow in January of 2020, is there anything else on that thumb drive?
No, there isn't.
Okay, so the only thing on there, just to be clear for the court, is the recording of Lori Vallow being served with Idaho papers.
That is correct.
Okay. Your Honor, I move for the admission of State's Exhibit 205.
Any objection?
No.
Okay. I request permission for the admission if I missed that, and then I request permission to play it for the jury.
It's admitted without objection, and it may be published.
Thank you, Judge. Your Honor, it appears the court system isn't connecting with the laptop. We'll try a different laptop, and then we'll do it again if you don't mind, because it's not displaying what it should be displaying from the laptop.
Okay.
Let's try another laptop. I'll get mine.
Rich, I think I got it.
There's always a step ahead. Thank you. Thank you, Honor.
Do you have any questions regarding that? So it is 14:39 hours on January 25th. Any questions? Do you have any questions for that? Oh, okay. All right, have a nice day.
Now, sir, those papers, were they part of an investigation into missing children?
Yes, ma'am.
And there were orders on the defendant to produce J.J. Vallow?
Yes.
Okay. And that was the service we just saw
Yes, ma'am.
of an order on Lori Vallow to produce J.J. Vallow?
Correct.
What date was that again? I apologize. I'm not sure I got the specific date.
It was served on January 25th, 2020.
Did you have any additional connection with the investigation into finding J.J. Vallow and or questioning Lori Vallow?
Yes, I did.
What was your next involvement?
My next involvement is I was assigned to execute search warrant.
Okay. And search warrant on what?
On the person of Lori Vallow, the person of Chad Daybell, a vehicle, and the condo.
Okay. And what date did you, were you part of a search warrant team?
Yes, ma'am.
Okay, so you weren't by yourself?
No, ma'am.
What date did you guys execute the search warrant involving Lori Vallow in Hawaii?
On January 26th.
The next day?
Yes, ma'am.
Okay. And so when you went to execute that search warrant, where were they found?
They were found driving a vehicle southbound from Princeville towards Lihue, which is about a 30-minute drive, and they were going to Kauai Beach Resort.
Okay. And how was it law enforcement came into contact with Lori Vallow and Chad Daybell?
As far as, like, the traffic stop?
Yes.
Yes, ma'am. There was a traffic stop initiated at Kauai Beach Resort.
Okay. And so at the traffic stop, who was driving the car?
Lori Vallow.
Okay. And who else was in the car?
Chad Daybell.
Okay. At the traffic stop, was anybody, taken out of the car?
Yes.
Okay. Who was taken out of the car?
Both occupants, Lori and Chad.
Okay. At any point, was Ms. Vallow given an opportunity to receive her personal paperwork or her personal items?
Yes, she was.
Okay. Can you tell us about how that happened?
So we provided her with a copy of the search warrant, and then we allowed her to take some items that she might need, such as her cash or if she had any medication or anything like that.
When you say we, who's we?
Myself, Detective Cataluna, and Lieutenant Collio, and there was some other people there.
Okay. So when you allowed the Lori Vallow to obtain some of her personal paperwork, where did you guys go to, where did you locate that paperwork?
At her vehicle.
Okay. Was she present?
Yes, she was.
Okay. What paperwork or items was she trying to have you give her?
Well, we were just going to give her back her cash from her purse and give her back some items that she might, I think she had some medication in there. And then because we had the search warrant, we looked through her purse and then we put it back in the car.
Okay. So as you're looking through her purse, did you find any credit cards or any information?
Yes.
What information or credit cards did you find?
So Detective Cataluna was looking through her credit cards and counting her money, and when he was looking through the credit cards, he handed them to me to put inside a plastic bag to give back to Lori whatever he didn't need for the investigation. And then when he passed them to me, I looked through them again, and I saw one with the name. I saw a credit card with the name of Tylee Ryan.
Okay. So when you found the items with the credit cards and the card with Tylee Ryan's name, did that stick out to you?
Well, yes, it did.
Okay, why?
Because she was part of the missing children that we were helping them look for.
Okay. So what did you do with the card that was in Tylee Ryan's name?
That was held back, and then I put it back in the car.
Okay. When you say held back from the stuff that the defendant was going to be allowed to take herself?
Yes, that's correct.
Okay. And you put it in the car. Where did you put it in the car?
On the front seat.
Okay. And then was the car itself searched after the defendant was given some personal effects?
Yes, ma'am, it was.
Okay. And was that search documented in any way?
Yes, it was.
Okay. How was it documented?
It's documented. We execute the search warrant, and then we recover whatever evidence that we need for our investigation. We bag it and tag it, put the report number, and there's a property number that goes on there, and then I sign my initials on there.
Okay. And does anybody take any effort to take photographs of that process?
Yes.
Okay. And were photographs taken of the search of Lori Vallow's car in Hawaii on January 26, 2020?
Yes, ma'am.
Okay. And have you had an opportunity to look at those photographs?
I have.
Okay. Let me hand you what has been marked State's Exhibit 234Z. I apologize, 234A through Z, a copy of which has been provided to the court as a courtesy, and a courtesy copy has been given to defense counsel before today.
Can I clarify one thing?
One moment. We'll do that in just a second. Okay.
And in the A through Z, are there any missing letters in there, Ms. Smith, just to clarify? I didn't look yet. I'm just...
I don't believe so, Judge, but sadly crazier things have happened.
I've got all of them in my...
Okay, good. I believe all of them are there, Judge. I did double check. Do you need water?
Oh, I have.